also. And this order was passed in
So what is the-
2023.
What is the urgency?
Your Lordship, this was a contract which has.
Where is the urgency is what we are asking.
Yeah, urgency letter has been circulated.
Not to be deleted. Not to be deleted.
802, no date is showing. 29th of. Oblige, Your Lordship.
None. Not to be deleted. 804. Take.
Item 1. Item 1.
Your Lordship,
Yes.
I'm requesting for passover in item 1.
Lordship.
You're in which case?
Item 1, Lordship.
Pasu.
Item 2.
But in item number 2, I have spoken with the opposite counsel, Mr. Ashutosh. We are ready for the settlement. We had a word, my lord. The clients also. We are ready for
For the limited notice.
Yes, my lord, and we are agreeing for the settlement.
The lordships were not able to reach the respondent wife actually. After the matter was listed on the listed in the advanced list, we've been trying to reach her. We're not able to reach her.
Then nothing can be done. It was a limited notice.
My lord, please pass over the matter or adjourn the matter for a week because when I had a word with Ashutosh, Mr. Ashutosh, he had a word with the wife. Maybe after a week or 2 weeks, my lord, maybe.
And counsel to the respondent to obtain instructions. List on 2 weeks.
Item 3.
Number 3, Lordship, online. Item number 3,
Yes, please.
Lordship, my case is is considered under relevant ex gratia rules, Lordship, because my application for ex gratia application was pending for more than 15 years, Lordship. That's why a London single judge has favored me on this point, Lordship.
You are the
I appear for the statement.
You have excellent case. What is weighing in our mind is, you see, there is death has taken place. 2.5 lakh rupees is what is payable under the scheme. The learned single judge had said that with the interest. Only thing is we can say this, that you pay 2.5 within 6 weeks.
Manoj will kindly consider the facts, Manoj. The death take place
in 1 minute. Mr. Rawat, what is it that you wish to say?
Yes, Lordship.
What is that you wish to say?
So I want to say that my application was pending for 15 years. The same has not been intimated to.
No, it was correctly addressed, prepaid.
Yes, yes.
Therefore, the statutory presumption is there that it was posted and you received it. Whether you received or not is a question of fact which can't be going into in a writ petition. What we propose to do is that 2.5 lakhs is payable as ex gratia. Minus the interest, we can at the most direct them to pay.
That will be.
Make one submission. I understand what has fallen from Maloj and it is only 2.5 lakhs, but Maloj, it's my duty to submit, Maloj. 98, the death take place, Maloj. 2015 is, Maloj, when the claim is made, Maloj. Ultimately, Maloj, compassionate appointment is, Maloj, for immediate, Maloj, succor to the family, Maloj. And under that scheme, Maloj, she applied, she was offered employment, Maloj. She did not join. The son, Maloj, was only 10-month old, Maloj. After, Maloj, 18 years to fall under a new scheme, Maloj.
They are only giving money, they're not giving a fund.
Manoj, I understand that, Manoj, but Manoj, she has to fall under the scheme, Manoj. At the relevant point of time, Manoj, there was no such scheme, Manoj.
Suppose if we were to reverse the finding of the DV with regard to the letter being posted and received.
Manoj, Manoj, yes,
Suppose.
Manoj, there's a judgment of this honorable court of Manoj, where Manoj have held that
Having heard, thank you. कुछ तो रहम करो. Having heard learned counsel for the parties, Glenn, we have the considered view that interest of justice would be best met if the respondent were to pay a sum of rupees 2.5 lakhs to the petitioner as a one-time settlement of all claims with regard to the consideration of his application for appointment on compassionate basis. We notice that the learned single judge, with a judgment dated 27th of March 17, had awarded interest on the said amount at the rate of 12%. Findings of fact, as also the directions issued by the learned single judge, stood reversed in an appeal preferred by the respondent here. Also, we also notice that the employee, original employee, expired on 25th, that pursuant to the death of the original employee on 25th of May 98, the applicant was minor, just 8 months old.
10 months.
10 months.
10 months. The date is 26th May.
26th of May 98.
98.
And only upon attaining majority on 16th of October 2015, he had applied for the appointment on compassionate basis in terms of the scheme floated by the respondent government. So, as we have already noticed, considering the entire facts and circumstances, while not disturbing the findings of fact in terms of the rendered in terms of the improved judgment, we direct the sum of these 2.5 lakhs to be paid to the petitioner within a period of 6 months. Needless now, should the amount, the particulars of the bank account be supplied by the learned counsel for the petitioner to the learned counsel for the respondent. Should the amount be not disbursed within 6 months, the amount would carry interest at the rate of 6% per annum.
Great out.
Let's have observed in the peculiar facts.
We have said in the attending facts, in the attending and peculiar facts. Attending की जगह peculiar facts.
Great.
Great out.
Please, my lord. My lord, I'm appearing for the petitioner in this matter, my lord.
Yes,
My
please.
lord, I'm seeking transfer of the section 11 application filed by the respondent at family Adra Court to the Vikas Nagar, Dehradun.
The transfer it.
Your Lordship, the matter is far more serious. May kindly allow me to submit some pertinent facts in this matter.
Certainly, most certainly.
Your Lordship, most humbly, Your Lordship, the marriage between the petitioner and the respondent never took place, Your Lordship. She is alleging the marriage to have been taken place on 15th of July 2016.
We know that you have filed section 11.
Yes, Your Lordship.
We know that.
Now, Your Lordship, when there is no legal marriage having been taken place between the parties, Your Lordship.
So which court would adjudicate that?
Certainly, Your Lordship. Even otherwise, Your Lordship, the respondent is now posted at Bangalore, Your Lordship. And it is approximate.
Answer. Thank you. थोड़ा
Highly obliged.
गर्म हो रहा है ये,
Your Lordship,
थोड़ा गर्म हो रहा है, एसी को थोड़ा ठंडा करो. थोड़ी बढ़ाओ. हाँ,
Yes, Your Lordship. Your Lordship, this is a transfer petition. Here the
This
sole.
is item 5. No?
Yes, Your Lordship. The sole respondent in this matter remains unserved.
Service is complete. No.
No, Your Lordship, it is not complete. The respondent remains unserved. Your Lordship are directed to acquire the daily address.
Sorry, unserved.
Yes, Your Lordship, the daily address is itself in the petition. Your Lordship may direct for service through family court, Your Lordship.
Why? You take the seat.
Yes,
Furnish
Your Lordship.
particular.
Yes, Your Lordship.
Your office report, respondent stands unserved. Let press steps of service complete in all respect by furnishing latest particulars be taken. The state in addition.
Oblige, Your Lordship.
Item 6.
1 minute, Mr. DK Singh, you are in mid matter, Mr. DK Singh? Achha, 6. Okay.
Lords,
Yes.
item 6, I'm appearing for the
You are appearing.
petitioner, my lords.
We have already discussed one of these applications, no?
No, my lords, this is the bail matter, my lords. On last date, your lordship was pleased to issue notice in this matter.
No, sorry. Similar matter we had discussed? No.
This is a bail matter, my lords. No, not similar matter, my lords.
No, I am getting confused there. Doesn't matter. Because you have 14 antecedents. So I thought that.
Lords, out of the 12 accused, my lords, 11 accused have been granted bail by the High Court and the Trial Court, my lords, in 2023, my lords. As far as, my lords, the
Kindly come to page 30, sir.
Yes.
Your name is, what is your name?
My name is Raja.
Raja, correct. You fired a gunshot. That's what the allegation.
Yes,
You're not saying. Kindly come to page 30 and 2 counts. 302.
Yes, my lord.
Rest others are accomplices. That's it.
My lords,
But your role is very direct.
one submission, my lords.
Yes.
My lords, in the post-mortem report, my lords, the doctor opines that there was no gunshot injury on the deceased, my lords. There was no gunshot injury and he died by drowning. That is come in the cross-examination of both the doctors in the post-mortem report clearly, my lords. And, my lords, one more submission, my lords. The other accused who also shot, my lords, and that below did not hit, he was also being granted bail in 2023 only, my lords, by the High Court, my lords. The post-mortem report may take your attention to lordship 223 and 226, my lords. Please number.
Yes. Finally, you see, there is another distinguishing feature.
Yes, my lords.
Kindly come to the counter affidavit, page 6.
Yes, my lords.
Therefore, I was getting confused initially.
Page 6.
You're all page 6 and 7. You're also a decorated person.
My lords, it's Rajasthan public gambling offences under this, my lords. They are not, and in most of these cases have been acquitted, my lords. Because, my lords, these are all under 341 and 323. Secondly, my lords, one more submission, my lords. Only 6 witnesses, my lords. Now only 6 witnesses have been examined, despite the orders of the High Court and High Court, my lords, that by July the trial should be complete, my lords.
16, not 6.
No, my lords, I'll submit, my lords. That's a wrong submission, my lords.
That's an incorrect submission.
That's a wrong submission, my lords.
Thank you.
Only 6 witnesses have been examined, my lords.
Thank you, sir.
Lord, the trial may be expedited. my lords.
Thank you.
Please, my lords. My lords, this is an anticipatory bail application. My lords was pleased to issue notice to protect the petitioner, my lords. No, he's been absconding since 2023, my lords. He's the one who is the mastermind of this, my lords. He's the one who has orchestrated the whole situation, my lords.
We
He
have
has
seen
paid.
your counter affidavit, you say. We have also seen that 7,680 bottles of cup.
Codeine, my lords. Yes, sir.
We have seen that.
Yes, my lords.
Now, we'll request one thing, sir. एक चीज करना है.
My lords, but I'll fairly submit he's been participating after my lords has.
Just 1 minute.
Yes, my lords.
Just 1 minute. Just one. We'll just pass over this case. We'll take it up along with item 70. Just be here with item 70.
May I please, your lordship? My lord, this is a tenant's, my lord, appeal. My lord, may I kindly turn to the impugned order at page 2, my lord. My lord, it says on 24/3/2015, the following orders were passed. After arguing for some time, counsel for the petitioner submits that the petitioner would be satisfied if a reasonable time is granted to vacate the revised premises.
I've only written here how much cost.
My lord,
I've only written here how much cost.
my lord, may I kindly see, my lord, two things.
Since we can
The
now
mandatory-
notice that.
My lord,
One minute. Gentlemen, 1 minute, allow us to complete. We notice that now a designated senior advocate is appearing, so the cost would be commensurate to the stature of the senior advocate, no?
my lord, I would, if I am able to make out a case, your lordship may kindly see.
Well, kindly, okay, the entire bar is here and we are
My
in a
lord.
digital mode. Please read the impugned order loudly.
My lord, I am reading that. On 24/3/2025, the following orders were passed. After arguing for some time, counsel for the petitioner submits that the petitioner would be satisfied if a reasonable time is granted to them to vacate the demised premises. Mr. Kanwar has given offer of 6 months. Mr. Gupta prays for time to file affidavit of the petitioner tenants. On his request adjourned to so and so, my lord. Thereafter, on so no counsel appeared and filed his power of attorney. Today, senior counsel has appeared and wishes to argue the matter. Once the matter has already been argued. Now, my lord, here I, my lord, pause. In fact, it was only a, my lord, consented order to file an affidavit on behalf of the, my lord, tenants who have refused to, my lord, give an affidavit. Now, my lord, they in the case, in the trial court, it's a judgment of reversal, my lord. And my lord, may kindly see the mandatory requirement of section 13, subsection 3, which is at page 38, my lord.
Okay,
My lord,
we have
kindly
heard you. We have heard you. The impugned order reads as under. In a
a
concern,
specific, my lord, affidavit saying that he does not have any other premises. Now, my lord, the trial court.
Mr. Counsel, we are imposing a cost of 1 lakh rupee.
My lord, may kindly not be that harsh. My lord,
We are
because
harsh. You are saying harsh. We are saying it is grossest abuse of
my
process
lord,
of
my
law.
lord, my lord, my lord, may kindly see. My lord, may
My-
kindly see. I'll not press it.
Yeah, 1
My lord,
minute. I
my
have
lord,
consulted my lord, and I was of the view that the cost should be very high, but my lord is very considerate.
My lord, then my request would be, my lord, it's a, my lord, commercial premises. I'm in and my lord possession.
Mr. Counsel,
Some
this is the
reasonable time.
grossest abuse of process of law.
My lord, then my reasonable time. My lord, may client me.
You
Because
know,
it's a,
let us tell you, let us tell you, when we
My lord.
used to practice here in this court,
My lord.
40% of the matters would come from Punjab and Haryana and Delhi only. Now things have changed.
No, my lord, I will not press it. Then my lord may kindly consider my request of granting me some reasonable time. I'll vacate the premises. Some reasonable time, my lord, may kindly be, because it's a only livelihood for me, my lord. I've got nothing else to depend on.
Okay,
Small children.
okay. How much time?
My lord may give me some reasonable time.
We'll give you 3 months.
My lord may give me at least 6, my lord.
No.
I have, this is the only, my lord.
Nothing.
This is the
Nothing.
only, my lord. This,
A small petty shopkeeper can afford a senior counsel of Punjab and Haryana.
my lord, I do not, my lord, my lord.
Will you give an undertaking or shall we dismiss with cause? You tell us that.
My lord may give, I will give it.
Having heard no, finding the bench not to be in agreement with the submissions made across the bar. Learned counsel prays for time and instructions. There is time to vacate the premises within on or before 3 महीने का डेट दे दीजिएगा. Let an undertaking to this effect be filed. Should the petitioner not file such an undertaking, the petitioner would be saddled with cost of these 1 lakh to be recovered as arrears of revenue, and the cost to be deposited with the Supreme Court Legal Services.
Grateful.
Please, my lords. My lords, there was a family settlement in this, my lords, annexure P1, my lords, at page number 26, my lords, where both the petitioner and the predecessor in interest of the respondent had agreed to take 1/2 share each in the property of their late brother, my lords. Now, my lords, the Honorable High Court has given us, like, if so advised, to go in execution for this, go in enforcement of this settlement deed, my lords.
Ma'am, you were not able to prove the issue, the burden which was cast upon you.
My lords,
And
as regards the
currently-
will, we couldn't, my lords, because it was an unregistered document. But my lord, this was a family settlement, my lords, which unfortunately, my lords, could not be placed on record before.
Whatever it was,
My lords may kindly be at least remand back the matter on
No,
this issue, my lords, because we have been given the liberty to file a fresh suit, but not the benefit of section 14, my lords.
at best, we can, you're there? Are you there in this matter?
Yes, my lord, Sukhvinder.
Bhajan,
Bhajan Singh.
Bhajan Singh.
So, Bhajan Singh, you're not there. We thought you were there. At best, we can, because it's a dispute between the
Two
blood
brothers.
relations, limited notice on settlement. That's all we can do.
Please, my lords, will be much obliged, my lords.
Limit-
My lords may kindly condone the delay, 25 days.
Delay is condoned,
Please,
limited to extent of exploring the possibility of settlement.
Much
Considering
obliged.
that the parties to the list are blood relation, close blood relation.
grateful, man.
But is a matrimonial case by the husband.
Yes.
My lord, there is no marital moorings for the past 12 years. They are living apart without any marital
What
solace.
can we do? How best can we help you?
My lord, I implore, my lord, a mediation, if my lord can resolve the issues, my lord.
She has filed RCR, that's anyhow, only limited only in the point of settlement.
Yes.
Limited to point of settlement.
Much obliged. My lord, can I impress, my lord, this honorable court, my lord, mediation before this honorable court, Supreme Court?
Let them come, no, sir?
Much obliged. Obliged. Obliged for accommodation.
My lords, my lords. It's against the allowing of the transfer application. It's been allowed from beyond what was prayed for, my lord. Taran was 50 kilometers. This is more than 100 kilometers. The comparative hardship is much more than me. My lords, had it been Taran, it was still okay. My lords, it's one. He's a complainant, my lords. He's a complainant. He's not supposed to go on every date of hearing for the trial, my lords. We are the ones who have to go for the trial.
Video.
Miss, legal aid could have been provided to the complainant, he would have been represented properly.
Thank you. Next.
My lords.
Kindly.
Affidavit आ गया.
So kindly see the password, my lord.
Password?
Please, my lords.
But affidavit has come now.
Yes,
We have seen the affidavit. Why are you seeking password? We have seen the affidavit.
So it's actually the senior counsel.
So no problem. Pass it on.
Great.
Yes, sir.
Yes, my lord. Service is complete, my lord.
Lords, we had got the respondents, unserved respondents served through the SHO. We filed the affidavit of service. And I'm not sure if they've entered appearance. I'm for the state.
Item 13, who are you, Mr. Singh?
My lord, I am for R1, my lord. I pray for 4 weeks time to file counter.
Any possibility of settlement, Mr. Singh? Any
My
possibility?
lord, as your lordship thinks.
Yes, this is a 304B, my lords. Sorry. Dowry debt.
Leave granted. Leave granted.
Problem.
Oblige.
Leave granted, report. Hearing expedited. Hearing expedited in November.
There is some confusion.
Lords, I appear for the petitioners.
There is a confusion, my friend. Term of 14 is. Please. My lord, may I please, my lord? Lord,
Notice is the issue. Notice is the issue to answer. Yes.
Lord, in this case, my lord, on the day I was granted interim relief by the DRT, my lord, the FIR was lost. For same set of allegation, my lords, an FIR was lodged on 4/8/23, my lords, for same set of allegation. Now they went on 8/8/23. On that day, I got relief from DRT. They lodges a second FIR. Now, my lord, that is my house, and I operate a school on the downstairs. So it is my living place, your lordship. And the entire family, including minor daughters, have been prosecuted in this case. My lord, let's say there was some criminality in this case. They would have made accused in the FIR which was lodged on previous day, my lords. The same police station, everything was same, my lords. They lodged a subsequent FIR with all these allegations, my lords. And this is the case of no injury, my lord. Entire ladies of the family has been implicated, my lords.
The senior counsel is appearing to us.
Yes,
Lord,
Mr.
due respect, I beg to appear, my lord, online with due respect, Lord. Lord, in this matter, Lord, this is not so simple matter, Lord. There is a tribal issue. They are coming
No,
here.
one thing is there. One thing is there. That the
Please, my lord.
very same day the FIR was lodged, he had gone to DRT, stay was granted.
Lord, DRT, this is a tribal issue, my lord, whether the DRT order was in the knowledge of the executors or not, Lord. Number one. Number two,
But
Lord.
it is not a fact that same day DRT order was passed.
Not earlier, 8 August, Lord, 8 August, they have completed. Please, my lord, if my lord see the page number, Lord, 5 of my counter for a moment, Lord.
We are allowing it in today's date.
I'm
My
obliged.
lord, page number 5, Lord, we have lineated, Lord, the tribal issues are there, Lord, because they have tore the document, they have obstructed. Please, my lord.
Thank you. Thank you.
I'm obliged.
Please mention.
Is there a request for adjournment by?
Your Lordship, there is a letter in this matter. We are praying
Sorry?
to, there is a letter in this matter. Your Lordship, we have circulated a letter on the ground of personal difficulty of health for the arguing counsel. Your Lordship, let this matter be posted after 2 weeks. There is some surgery in the.
Okay.
The Lordship has directed them to comply the order. That's why this matter has been listed. I'm not opposing his on his health ground, but
The arguing, what is the name of the arguing counsel?
Pramodlata Das, Your Lordship.
Is not attending court work on account of personal ailment. As such adjournment is paid for. List on the date, the higher committee. Be ready that day. It's an important.
Please, Your Lordship.
some fixed date may be given.
You already said.
I'm deeply obliged.
Tuesday.
Lordship, actually in this matter, page 156, madam, the same judgment is being examined by this court. Leave has been granted, my lord.
Number 50. 15 तो हो गए 16 में 6 leave has been granted.
Leave has been granted, my lord.
Leave granted.
Lordship, may I just make a request, my lord?
Yes.
May I just make a request and suggestion, my lord, if it is, if your lordship consider that much. Lordship, may see at page 14. Just one thing I want to suggest, my lord.
What is that? Please tell us.
Lordship, he has undergone 5.5 years, my lord. And this is a case of suicide, my lord. Admittedly a case of suicide.
ये जो page
Lords, no, my lord, my only request.
Page 156 पे जो order है वो कर दो. Tag कर दीजिए.
No, bail is granted, lord.
No.
He has done 5.5 years, my lord. He has given 10 years, my lord.
Disease has died within 2
1 minute, gentlemen. What is this practice?
He has
Still on his legs. We are.
He has been given 10 years, my lord. He has done more than about 5.5 years. My suggestion was, my lord, Lordship, my suggestion is little, if Lordship kindly consider, Lordship, others are granted 7 years. If he is reduced to 7, he will not press his appeal. That's my instructions also, my lord. If it can happen, my lord. If Lordship can kindly consider that part. Because
just one minute, sir.
Page 40.
We'll have to then You are given how much?
10 years, my lord, and others were given 7 years. My lord.
No, 1 minute. Would the others be pressing then? The law is if 1 minute. If they are acquitted, then you will be acquitted.
That is true, Lord, my lord, but
they are pressing. Is what
they are different council, my lord, and they are mother and father.
we might as well do one thing. We'll list all of them together. If others also say we are not arguing on merits, maybe then we can go.
Lordship, they will not say, my lord.
Lordship,
why I'm saying they will not say, then Lordship may grant leave. My only thing is, my lord, they have done only 1 year. I have done 5.5 years. My sentence, I have minor children, my lord. Yeah.
The law is this that
I will not press my appeal, my lord. That's
under instructions submits that petitioner does not intend challenging the judgment of conviction under section 304 the IPC. The limited challenge in this appeal is confined to the quantum of sentence, primarily on the basis that similarly situated co-accused stands convicted for a period of 7 years, whereas the instant petitioner, stroke appellant, stands awarded sentence of 10 years. ऊपर leave grant कर दीजिएगा, फिर appellant हो जाएगा. What do you say now?
Lord's High Court has sentenced him for life. High Court has modified to 10 years already. And Lord's, the deceased has died within 2 months of marriage. The demand of dowry is proved. And even the money from where the demand is procured, that is also proved.
What more do you wish to say? You have not challenged the appeal. You have not challenged the order of sentence. We are only asking you, you are not here. The offense took place in the year 2004. Today we are in 2025. He has already undergone 5 years. He is ready to undergo remaining 2 years, considering his age and the children. He says, please have a considerate view, if not a compassionate view, and make it 7 years. Now you tell us what you want. We are in your hands.
The judge
will not put it in your mouth what we say, but what is your view? Having heard learned counsel for the parties at length, we have the considered view that the High Court, in terms of the impugned order, ought to have awarded equal sentence to all the accused persons. More particularly, when the findings for role of each one of them was found to be similar in nature. The crime took place on 30th of April 2004, when unfortunately the deceased died in the matrimonial house. She committed suicide by hanging. Since the learned counsel, since the appellant does not challenge the judgment of conviction, we need not refer to the other, need not refer to the other facts insofar as the finding of guilt returned by both by the trial court and the high court is concerned, which is based on the testimonies of material prosecution witnesses, bracket में 7 in number. Insofar as sentencing is concerned, we do not find the High Court to have drawn out any distinction between the roles of all the three accused persons, three convicts in the commission of crime. As such, we are inclined to accept the request of the secretary. We also notice that that neither the state nor the complainant has challenged the findings of challenge the judgment and conviction of the High Court by way of an appeal. As such, we reduce the sentence of appellant Sukhwinder Singh from 10 years to 7 years in connection with his conviction under section 304B IPC. So, the accused shall surrender.
He's already in jail.
The accused is already in jail and shall serve the sentence. And shall be released on the completion of the obliged. You are for whom?
I'm for the respondent, Your Lordship.
We were wanting you to. We are glad that you are here. In fact, I had spoken with my lord. We thought we'll request you to be a witness in this matter.
But
Since you are there,
I'll try my best to assist Your Lordship.
Since you are there, see what we intend to do. We'll tell you. We'll keep these matters.
And if permitted, Lord, I would submit that who knows better than Your Lordship regarding this particular excise act.
In fact, what
Bihar Prohibition and Excise Act. Your Lordship had occasion to deal with not less than 20,000 cases.
What we'll
I'm
do
aware
is,
of that.
What we'll do is that we will keep this matter
By
Friday.
This Friday.
Next Friday? Next Tuesday. If you're here, Tuesday, Wednesday, Thursday, or a week thereafter. A week or 2 weeks. What we propose to do now is this. We'll request you, today we'll not record, we'll request you, if possible, to provide us a data as to how the litigation in Bihar has, ever since this enactment came.
I'll try. I'll try to obtain the data. I'll try to assist Your Lordships.
And based on that, we wish to pass some orders because, unfortunately, you know the position better. You may prepare a note, give it to us, which will be part of our order. And then we'll make a request before Honorable the Chief Justice of India also, so that those matters which are already pending here, they can be expedited.
Unfortunately, means since 2017,
correct,
that matter is pending.
Correct. So but here none has challenged the virus of this act.
Subsequently, amendments have been made, Lord.
No, we are
in this
saying
present.
this particular provision.
Yes, Lord.
See, is it not transgressing Article 22 that you walk into anyone's house?
I will make my submissions, my lord. I understand, Your Lordships, that the point Your Lordship is examining in the larger perspective. I understand. my lord.
How, what? See, if a man is on the road, is one thing.
I completely understand if the provision of the act is
Only that if he has consumed alcohol and is sitting at home, that's all. He is neither a drug peddler or he's not a peddler, he's neither a stockist. He's just a consumer, that's it. And he's not creating any nuisance. What right do you have to enter into his house without notice?
Lord, I can answer. my lord.
Is it not violated of article? We are not
I
saying
understand.
it is.
I understand. My lord, the provisions of the act is like this, and your lordship is right. Your lordship is right that it has to be examined in prospect of Article 21.
Correct.
I understand.
No, without even notice, you just walk into his
And
house.
because that takes us to the challenge to the virus of the act on the basis of constitutionality. my lord.
And we don't mind doing it here. We don't mind doing it here.
It would be rather better, your lordship, if your lordship decides this issue once forever.
At
And
least,
because
at least this portion, this particular provision I have not dealt with there.
Yes.
Therefore, I can do it here.
Yeah.
And I would not be precluded from doing it.
Actually, your lordships, I have been told, my lord, that on the last occasion, one question was raised by Honorable Justice Mishra regarding, and that question, according to me, is very pertinent, my lord. His lordship's question was that suppose somebody is consuming wine outside the state of Bihar, the border is porous, and he comes within the state of Bihar, and you put him to breath analyzer test. Can you prosecute him under Section 37? Even if it turns out to be positive, can you prosecute him? Because he has not consumed alcohol in your state, and your jurisdiction is not beyond the state. And that is how, your lordships, I can demonstrate in this particular matter that how the provisions of the acts are being misused.
Absolutely, absolutely. And today, sir, may I also inform you that the entire police force of Bihar is working only for this offences under this act. There is none to take care of crime and order situation. That is the effect of
Lord,
the act has been substantially diluted, my lord. Even for the consumers, there is no punishment as such. Though those who may consume alcohol and for this particular matter, basically he is concerned about the departmental proceeding.
No, not only that. Second offense is conviction, if I correctly remember.
Second offense is
1 month only.
Lord, second offense is conviction, and even first offense has clogged the entire judicial process of the state of Bihar.
Absolutely. So therefore, it is only, I have discussed it with my lord. In fact, when item 7 was going on, then I saw you sitting here. We thought we'll appoint you a amicus in this item 17, but we have.
I don't mind to work in that matter also, Lord. If your lordship so wishes, I'll surely assist your lordship to the best of my ability.
Item 7, then we'll. Item 7 था ना?
Yes, my lord.
Item 7 तो मध्य प्रदेश का था ना?
Yes, my lord.
तो फिर
कब सिरप में?
कब सिर्फ है तो वो तो लॉ कर देते हैं तो just we'll allow it, ma'am.
Interim is operative.
Interim.
Yes.
This is allowed. So item by when do we?
Lord, next week I'll have some difficulty, and since I have to collect data, etc., your lordships have said, I'll ask for time for 2 weeks at least.
Okay, and propose issues and propose whatever we can do. You just
My lord,
do a note and we'll put it in order.
I'll surely do that. I'll surely do that.
Shall we record your presence or shall we say amicus? Okay, no, presence.
In this case, Lord,
Correct. List on as prayed. We have requested Shilpan and senior advocate as also, what's a good name?
Manish Kumar.
Manish Kumar to provide certain information for the next day. List on put it in here. 2 हफ्ते के बाद Tuesday.
Lord, State Council may also provide the data and then figure because they have all the statistics.
I'll try to collect because some data is already there that has been given in some other matter.
Are you here next week?
Next week, your lordships, I have some difficulty.
No, we'll have it any day. What we'll do is we'll have it this Friday.
Lord, I will just request your
Only
lordship.
for data.
Friday is perhaps 15th August.
Some more time may be given, so by data may be collected in a correct perspective.
NIC से मिल जाएगा, हम ही बोल देंगे ना डाटा, आप ही बोलिएगा. What we'll do is हम इसको Thursday को रखते हैं, list on Thursday. Thursday को है.
Yes, your lordship.
Just give the data and then.
And permit me, Lord, to join virtually if.
No problem. No problem.
Data with respect to pending excise cases.
Correct. In Bihar.
At all levels.
At all.
Levels. At all levels.
Obliging.
Thank you.
In this case, so far as I am concerned, I was a protected tenant.
Who is in possession?
I'm in possession. That is because they filed even a suit in 2007 saying that for injunction, and the court said they are not in possession. There is a direct.
Delayed by
injunctions.
Please, no,
So delayed by 10 years.
that's what I don't know. That is, of course, one area which I have to point out to your lordship. What has happened in this case? So there was preemptory order in 2010 that in case some LR is not brought on record, it will be automatically dismissed, my lord. Thereafter, my lord, there was no communication and there was no intimation, and thereafter only when they filed a suit.
10 years delay is not explained. That's what we are saying.
Yes, ma'am. And they filed a suit in 2007 for injunction. The court found that they are not in possession. I have produced that order.
We are only saying what is the.
I'm sorry, my suit was dismissed on the ground that the writ petition was pending before High Court. When writ petition is pending before High Court where there is status quo order, I cannot give any such order. That was the reason for which my suit was not for on the merits.
Kindly come to page 110, my lord. The finding recorded by the civil court. Page 110.
For the fourth round of litigation, your lordship, the material point is on 1374 RU a tenant. It's on law. One must be tenant on 1374. If he is not there, from 53 till 74, he is not.
Who are you?
I'm the purchaser from the landlord, your lordship. Now I'm in possession of the land.
110, your lordships may kindly see the finding. No, but this is because your lordships may kindly see, so far as I am concerned.
10 years delay is not.
10 years delay, my lord, your lordships will find I have given sufficient cause, my lord, your lordships may kindly.
You don't find. Sorry.
Your lordships may kindly see I have given because it is only when the suit was filed in 2007.
Sorry, ma'am.
I got the summons from that, my lord. I came to know that there is a dismissal of this.
Sorry, miss.
Your lordships are dismissing on the ground of delay.
We are not interfering. That's what the courts have held.
But the court has gone on the merits of the case also because agricultural person who had admittedly he is in possession, my lord.
No, sorry.
Because even the court has recorded the finding that I am in possession.
We are only saying dismiss. That's all. Thank you.
There is a land tribunal order which is in my favor, my lord, partly.
We have seen that. Thank you.
Grateful, boss.
19, we are being led by the SGs in that suo moto matter concerning summoning of lawyers. Both parties have filed written submissions. An interesting question of law whether the Government Grants Act would apply or the Rent Control Act can be used to in fact override the conditions of the lease itself.
Correct.
My lords may have it on some day because the SG wishes to address. There might be some discussion between a 4-judge bench judgment and a 3-judge bench judgment. In fact, a perusal of the impugned order of the High Court makes it clear.
Correct.
Question of law that may have to be decided.
Learned SG, we know, is very, very busy.
Lord, there is a status quo operating against us.
But we want to decide.
Absolutely, Lord. That's
the status quo has to be there. Otherwise, I am put out of that property. Government officers are occupying that.
Yes, Mr. Patwali.
But I am here to assist your lordships.
Oh, certainly. Yeah. Today, we are told SG is busy. You do one thing. You check up from the learned SG.
Please, my lord.
Whatever date and time suits him.
Correct.
Absolutely.
Correct. Let it be one. Certainly, as per my lord's board.
No. See, 2-3 times it has been adjourned only on him.
Please, my lord.
So you tell him, be it 10:30 or be at 4 o'clock, doesn't matter. Or even thereafter. But whatever date and time suits.
That way, we also have some certainty because some judgments will have to be read, and so you just go on reading and then.
An important issue.
Correct.
Certainly. I will take instructions and I'll inform.
We'll just pass it over. So let us know, please.
All right.
Just
Great.
at 2 o'clock, we have the other matter.
Correct.
Please, my lords, I appear the petition in this matter. Letter is circulated.
Shri Miss Malushri Pathak, who is to argue the matter, is not attending court work on account of personal ailment.
My lords may give a shorter date, 2 weeks.
Yeah.
My lord, she has fractured her leg. I'm seeking 6 weeks time in this matter, my lords.
My lord, since 1 year this matter is not reaching end, since April they have been moving adjournment letters.
Lawyer's leg, fractured leg, what do we do now? Tell us.
My lord.
List on after 6 weeks.
Much obliged.
6 weeks.
6 weeks, she's.
Second week of September. If it can be on the 10th or the 11th of September, my lords, the reference will also be over by.
You tell us.
My lords, 11th of September anytime.
Based on
11th is Wednesday.
the password.
Thursday. 11th is all right because there will be less miscellaneous in any case on that day. 11th is all right.
11th of September.
High up kar dijiye.
Hiya. Great.
Pleasure.
Maybe please. So an interesting question, but before I begin there, I must say not as to what stands in my way. What stands in my way is an clear dismissal of my 11 by this court and a review being dismissed. But having said that, not if your lordships were to look at just one glance at the order that this court had passed on the previous 11, I'm sorry, which is Mishra. On the previous round, it is my respectful submission and humblest submission, not that view that this court took is completely contrary to a long line of judgments prior to that and after that. Please kindly have the first round. I must get over that before I invite lordships to not consider the question that's arising here. Kindly come to my lord page.
Even if it's a wrong view, in between the party which is binding,
But
you may find a review.
I could have understood. I did. May say,
Otherwise, there will be no finality in the
may I say this, Lord?
party.
I could have understood if it was not an 11. This was a judgment on merits. I could have understood. In which case, not the parties are bound, inter se. Inter se the parties, it binds them. This is a 11 order, which is not only a referral order. It's not deciding anything on merits. And please, and therefore I submit that that principle, it is my understanding, may not operate here. That because there is no res judicata. There can be, really speaking, no bar in that sense. Why I say? Because it's only a question of reference. And nothing has been decided. Nothing has been decided by the 11th court. Nothing has been decided by the arbitral tribunal because the tribunal was never constituted. Can I just invite the court into the first round? Kindly see, my lord, the order.
No, are we to reopen that?
But bear with me for a moment as to why I say, for an order that is wrong is not even res judicata. Lordships have held that in my favor. So, but not just, and more so when it is 11. It's not a judgment in that sense.
Unless it suffers from inherent lack of jurisdiction.
But may I say this, not?
If it is inherent lack of jurisdiction, you may argue.
I bow down.
But when the court had jurisdiction to pass that order.
But in an 11, your lordships are not deciding anything. Can I just formulate the point? There's something interesting, and I say so with respect and responsibility. I'm conscious of.
Women, please don't say that there is a point. Yes.
So therefore,
but no, we are not inclined.
Can I just try and canvass the point?
No, certainly.
I'm deeply obliged. Kindly come to 196.
What is wrong with the order? You first tell us that.
Precisely, Lord. Let me begin by first dealing with the stumbling block, which is the first round. Let me begin with that.
Correct.
Before I invite you to the impugn order, because if I don't get over that, there's no question of lordships going into the impugn order.
Correct.
Please kindly come to annexure P28, 196.
Correct.
Now kindly see Lord 17. Paragraph 17. This is
straight away come to para 18.
I'm going to show para 17 and 18.
Okay.
17, 18, and 19 is what I was going to read to the court. Can I read from 17 or lordships want me to go to?
No problem. You read the way.
17, I'll read, Lord. It is true that there cannot be a rule of its kind that mere allegation of discharge voucher or no claim certificate being obtained by fraud, coercion, undue influence practiced by other party in itself is sufficient for appointment of the arbitrator unless the claimant who alleges that execution of the discharge agreement or no certificate was obtained on account of fraud, coercion, and undue influence practiced by the other party. Now, please mark this. This is the reasoning of this court, and which is completely contrary to the statute 11(6)(a) and brought to the bind.
Now kindly come to para 18.
Can I just read the next few words?
No, we have read it.
To produce
how do you overcome para 18 finding?
I will read para 18 to the court. In the instant case, according to me, the error gets committed in 17, which is to expect me in an 11 to prove prima facie that not it was obtained by coercion. That's the error in 17. Lodges have held 11(6)(a) is agnostic of any factual inquiry. The limited window that there is to see whether there is an arbitration agreement or not.
See, when you read para 18.
I'll read it.
Now read para 18.
Deeply obliged. In the instant case, the facts are not in dispute that for two incidents of fire on 25th September and 25th October 2013, the appellant company, based on the surveyor's report, sent emails on 5th May 2016 and 24th June 2016 for settlement of the claims for both the fires dated so and so and so and so, which was responded by the respondent through email on the same date itself, providing all the necessary information to the regional office of the company, and also issued the discharge voucher in full and final settlement with accordant satisfaction. Thereafter, on 12th July 16, the respondent desired certain information with details that too was furnished, and for the first time on 27th July 16, it took a U-turn and raised a voice of undue influence coercion being used by the appellant, stating that being in financial distress, left with no option then to proceed to sign on the dotted lines. As observed, place in itself is not sufficient unless there is a prima facie evidence. This is the error, my lord, with respect. Unless there is prima facie evidence to establish the allegation of coercion.
Therefore, you have to seek a review or you have to file.
I did. I filed a review. I filed a review.
So therefore,
whatever you are arguing, those have been considered.
With respect,
Para 79 of the judgment.
my lord, with respect, with great respect, what you lordship see, my lord, just kindly bear with me for a moment.
We understand that it is unfortunate for you.
Well, may I just say this? Please see, in view,
also.
but in view of, I'm conscious of it, but there is something that lordships would want to consider in my respectful submission. 17, 18, and 19 is a clear error. But kindly see, it's a question of not at gate itself. I have not been allowed in. The proceedings haven't commenced.
Then file a suit.
But then please observe that, because I can't be nowhere in Boghara. In Boghara, your lordship held that it is triable. Boghara, your lordship held.
Whatever 12, 14 limitation.
I'm deeply obliged. Please observe that. I can't be remediless. I may have a case, I may not have a case, but somebody has to try it. Somebody has to try it. You have sent me out at 11. I have no remedy to file a suit.
You can always say you've been pursuing it bona fide. Well, we will not allow that.
Now, please see in view, my friend is right.
Don't give us certain.
For a moment, just one more indulgence. Please have para 11, para 21 of the earlier round. Just kindly have it for a moment. I had marked that also. 214.
Yes.
And PC brought in view of this observation, which court will entertain my suit? Para 21. In the instant case, prima facie, no dispute subsisted. After the discharge voucher being signed without any demur or protest, and claim being finally settled with accordant satisfaction. These are all findings with great respect. I can never approach even a civil court. And in an 11, when there is in the statute 6A, and there are judgments of this court saying that you have
just one. Page 215 order.
Yes, my lord.
As you saw a review of it.
I did.
Correct?
Yes, I did.
Now, we are putting it to ourselves that review having been dismissed, now is it open up for a two-judge bench?
But if I
just
please, absolutely.
Is it open for us, sitting in the combination of two-judge bench, to reopen what has been said and
with respect, there are precedents which support me on this. Your lordships have reopened when your lordships found that there is some error, and it is the bounden duty of the court to correct it. But with respect, even it would begin with that. With great respect, it would begin with that. I can't go to a larger bench, not on this. The review was filed, dismissed, and there is a clear, if I may say so, there is a clear error It's contrary to the statute. Lordship, see that. It's contrary to the statute.
Curative is yet another option with you.
In view of the subsequent judgment and overruling of
DMRC.
21 in subsequent judgment, now para 21 may not be that damaging to you.
Please observe that, so that at least the court below, the first court of the court of first instance, is not led by these observations.
What your lordships are not told that after the review, after 1 year, he moved an MA also in a disposed of matter. That MA was also dismissed.
One thing is there.
And after 900 days of that, is this new section 11?
Now that you have spoken, one thing is there. We have closed the matter.
Yes.
But have we not committed an error?
May I point out to your lordships why your lordships did not commit an error?
Yes.
Your lordships, as the law then stood, said that as far as an accord and satisfaction is concerned, no dispute survives now. Later on, the law said that under a section 11, all that can be decided is whether the existence of an arbitrable dispute is not there. But the court on merits in the Supreme Court judgment had ruled to say there is no accord and satisfaction, as my lords rightly said. What about the finality to the inter partes dispute? Principle of law has been set aside. The judgment has not been set aside. Neelima Srivastav says that the judgment remains, inter partes decision remains. What has been set aside is the principle of law.
Let us follow that. Would be just irremediable.
That's right, Lord.
Now there is a remedy. There
I'm
should
deeply
be-
obliged.
Should be a remedy.
I'm so deeply obliged.
There should be.
But
According to him,
yes,
there is a claim.
Yes.
You say there is no claim.
No, my lord, Supreme Court has said. Supreme Court has decided. My lord, Supreme Court has decided. Supreme Court has decided to say.
For a civil suit.
Yes. No, my lord, but Supreme Court
wants to pay court fees.
My lord, but he can't take a certificate from your lordships to go and sign
They
it.
are not certified.
Absolutely. He has to avail of his remedies, whatever are there.
If it is maintainable.
Yes, absolutely. That's for him to speak.
With greatest respect,
He
it's
will
not as if
not
the
be
later.
that, if at all.
With greatest respect, it's not as if the law changed later. The law was the same as in from 2015. 6A was in the statute. The judgment is contrary to the statute.
Suppose we'll say that you propose you intend filing a civil suit.
No, that's all I can do. That's all, because there is no arbitration now. All I can do is file a suit, and this would not come in the way of my.
My lord, your lordships. Please keep in mind, this court has held that there is no accord and satisfaction. As far as there is accord and satisfaction, and the review against that has been dismissed.
Without evidence.
Manoj, all that I'm saying
Then
is
there is a plea of coercion, undue influence, and fraud.
Yes.
Without evidence, while dealing with 11-6, we will record a finding.
Manoj, your lordships, right or wrong, have retracted a finding.
Trial. When there is some
But
party
all that I'm
claiming-
saying is, my lords, that's
How can you throw any person
that
out
is
of the
his-
court
that
without
is-
a trial?
Manoj, today there is a finding with a review order.
If there is no arbitrable dispute, where is the occasion to say that full accord?
Because
there
the
was no undue conflict.
I'll tell you, lordships, why. The reason
matter of evidence.
No, my lords, why it was said was because there is accord and satisfaction, there is no arbitrable dispute.
Liberty to file.
My lords, all that I'm saying is,
we can't close the doors of court.
I didn't say so, my lords, I didn't say so. I am happy, let him file a suit. I have no difficulty. Let him file, but it can't be that after a finding of your lordship with the review, your lordship says you are permitted to file a suit. That's all that there is a decision, right or wrong, with the review.
Clear the language, what
All that I am saying is
what he will dictate, but what.
because I should be left open to raise my objections. I'm happy, let him file a suit.
We'll say that all parties are at liberty to raise all.
Manoj, that's his statement that he will file a suit.
Correct.
And parties will be left open to raise objections, whether it's maintainable or not. Yes.
That's what we.
Because I'm sorry, but I can't go into arbitration. I can't go to a suit. So what's my remedy? I ask myself now.
Likhiv. When counsel for the petitioner submits that petitioner intends filing a civil suit, enforcing his remedies, vending out his grievances and enforcing his remedies. Well, it is always open for the petitioner to do so. And should the petitioner file the same, the court shall decide, the appropriate court shall decide the same in accordance with law. All contentions, subject matter of
one more aspect,
subject matter of the present petition are left to.
Well, all contentions, including maintainability. I will raise an issue in law.
All contentions will include.
One more aspect. Section 14 of the Limitation Act. I shall just make an observation because would come otherwise not maintainable.
That I will argue there.
All contentions on merit are left open to be raised by the parties. Suit. However, we clarify that since petitioner has been pursuing the matter before different forums, the issue of limitation in the suit shall not come in the
Well, our respectful submission is, why can I not raise this issue before the court concerned? Well, today I have a decision, a review in my favor, and an MA dismissed. Right, wrong, this court has done it. Well, let it be left open for the civil court to decide.
Not the limitation.
No, why can I not argue that it's not maintainable?
Not the limitation.
Manoj, he has, please keep 3 dates in mind.
One thing.
Manoj, after the review. Yes.
See, we were prima facie of the view that we committed a mistake at that time.
Right.
But only because our hands are tied up today. Perhaps.
Yes.
Perhaps. Or we are open to examine whether 2-judge bench can reopen.
No, Manoj, I'm not even going that route. I'm happy with the suit route. I'm just pointing out. I'm pointing out is one thing. I'm just pointing out one thing to my lords and your lordships, but then whatever order your lordships wants to pass. From the date the review was dismissed, he filed the current section 11 from which the impugned order arises 900 days later.
That's all.
Manoj, all that I am saying, no, Manoj, it is a point. That is why I am saying. No, Manoj, with great respect. Manoj, if 3 years later he files a fresh section 11, can I not raise the issue of limitation in a suit? Even a suit would have been time barred 3 years have elapsed.
Let it be adjudicated.
Manoj, let even limitation be adjudicated, my lord. Manoj, 900 days from the date section 11 is moved there.
We have committed a big mistake at that time.
Manoj, I don't think your lordship committed a mistake, but be that as it may, a review has been dismissed against that. Very well, my lord. Very well.
Most grateful. Deep reply.
Lordship, coming up after notice.
Sorry?
Coming up after notice, the only point is how that
Yes.
How the clause 25 is to be interpreted.
Yes.
There is a recent judgment on this.
Lordship, there's a recent. Sorry.
Yes, which is the judgment?
Lordship, BGM MRPL versus Eastern Coalfields.
Citation?
Lordship, will just give me a moment.
2022, is it 2022, volume 20 SCC?
Lordship, it's a. It's 2025 SCC online SC 1471.
Just 1 minute.
2025.
By Justice Narasimha?
Yes, Lordship. Exactly correct. 2025 SCC online SC 1471. It's civil appeal number 2141 of 2024. 21451. Pardon me, Lordship. Lordship, it's squarely on the point.
Yes, sir. Have you seen that?
No, my lord, I have not seen it. My lord, your lordship may just pass it over.
Lordship, the arbitration clause is at page 46 of the paper book.
We'll then you go through the judgment.
Yes.
We'll also go through the judgment. We'll have
Lordship,
it next week.
Lordship, I have the judgment. I can read out the paragraphs. It's squarely on the point, Lordship.
Your lordship may have it Tuesday.
1 minute.
Let him read, Mr.
Yes, just read.
Rohan.
Yes, Lordship. I'll just read out the relevant
Let him
portion.
read it. Let him read at home.
Mr. Ganpati,
Yes, Lordship.
we will also read it and then we'll come back next week.
Not only he, we also.
We'll come
Lord,
back.
I'm sorry, I didn't see.
Doesn't matter. We have to be we have to keep ourselves abreast of the latest law or no? Next week.
Para 22, if Lordships will make a note, that's the relevant paragraph.
Para 22. Yes.
Please.
Monday, Tuesday को दे.
Obliged, Lordship.
Tuesday high up कर दीजिए.
At 23, last time when the matter was listed, my lord directed them to take instructions within how much time they will make it.
Yes, there is a suggestion from my lords that if there is a possibility of settlement, but I have sought instructions from my client. My lords, today we are paying a rent of 10,000 rupees per month, my lords. My lords, I have instructions to say that we are willing to pay a monthly rent of 40,000. We are willing to increase the rent to 40,000 from 10,000. Those are my instructions as far as the settlement issues.
We'll reverse the findings.
Well, the knowledge will kindly hear me on
Obviously, we'll have to hear you, but we are giving you our mind.
Well, I had put it to my client.
That's all right.
My instructions are that, my lords, as far as the rent is concerned,
he's not
increase the rent.
Yes.
It's as far as the issue, because this suit for eviction, my lords, which was filed by the landlord, it was
only on the ground of limitation.
Yes, it was dismissed by the trial court on the ground of limitation, my lords. The appellate court reversed that finding.
Correct, and
the Honorable High Court has confirmed the finding of the trial court.
Correct.
Because the relevant provision is Article 66 of the Limitation Act. Let me just kindly have Article 66 for a moment. Mary.
How would a limitation apply? I don't understand.
Eviction petition,
Sorry.
the suit will be barred by limitation.
Now let's just
And once it is barred by limitation, it is always barred by limitation.
For that particular ground, so if there is a fresh cause of action under
What
the
particular ground? If there is a ground made out under the Accommodation Control Act or rent
control,
whatever, that's a cause of recurring cause of action. As long as the wrong committed by the tenant continues, it furnishes a cause of action, continuous cause of action.
No, what the provision of section 66 is that, because in Malats may have considered the facts of the present case. Malats, what had happened, the eviction was sought on the ground that the tenant had constructed unauthorized permanent construction. So that was the ground. But this construction was carried out in 1984 and the suit is filed in 1998.
Correct.
Let's then kindly see Article 66 of the Limitation Act.
66 is not between landlord or tenant.
Yes, let's kindly see.
It's between the owner.
Yes.
And the person who is in wrongful.
But it comes under Part 5.
His petition is not wrongful. His petition is not wrongful till he is evicted. A tenant always becomes remains in lawful possession.
That's true.
66 would not apply.
Let me just see. For possession of immovable property, when the plaintiff has become entitled to possession by reason of any forfeiture or breach of condition. Now, here the issues of breach of condition.
No. 67 will apply, Article 67 will apply.
Now, assuming 67 also applies, now let me kindly see 67. By a landlord to recover possession from a tenant, 12 years when the tenancy is determined. Now, in this case, there is no determination of tenancy by the landlord. Now, 67 there is.
How much time?
We told
him. Now, let me just consider on merit.
We are telling you.
They already sublet, Madam.
1 minute, just a minute. We are telling you, gentlemen. We'll just pass it over. Tell your client that we are allowing the appeal. Should you want time, we'll fix a time. No difficulty. Tell him.
I'll see this.
We are passing it over.
I'll come back in 5 minutes.
No problem. We'll also come back in 5 minutes.
Here he has misled the court. It says he raised a false plea before the trial. I would just demonstrate that because he.
Don't argue on merits now. We have heard you. Question is only of time. If you want time, we'll give you reasonable time. No difficulty.
I'll see this.
Just be back in 5 minutes.
Yes. Yes, I've sought instructions. My lords will pass the order on merits. I don't have instructions to.
Please. Well, it will be in today's day. Allowed in today's. Yes, allowed in.
Only one point to mention, my lord, because he has already sublet that property to
But
another
this is never
person. That I have
prepared
already
in
filed my
the-
additional document. That's the
This
I want to
ground
mention.
for the first time in the Supreme Court, these points are raised.
We'll direct you to revocate within 6 months. It will be a judicial order.
Grateful.
The subtenant is a party here? Subtenant is a
Subtenant
party.
is not party.
This plea was
Yeah,
never
I'm just-
raised.
I'm just
This for the
mentioning,
first time before my lords they are filing it, and yesterday evening they filed.
No problem, it will be
Yeah,
allowed,
this
it
is
will
the-
be a direction to get within 6 months.
Great.
My lords, in item 20, I'm requesting 2 weeks time to. My lords, I'm requesting 2 weeks time to file the rejoinder in this matter.
Item 20?
For your lordship.
No, rejoinder for what?
My lords, by way of last order, your lordship has indicated that.
Have you seen the counter? Financial loss was caused and only 50% is recovered. That apart, you ignore his counter. It's a case of compulsory retirement and no recovery to be effected from you.
My lords have limited instruction. My lord, counter was filed on 4th of August, my lord.
We are ignoring his counter. Because you see, you have been compulsorily retired and no recovery has also been effected from you. And that order of the tribunal has been affirmed by the High Court.
My lords, kindly grant 2 weeks time to file the rejoinder.
Listen. So it's lifted.
Lord, there is a recovery from him. I just may point out. The High Court has said that there is to be recovery from him. The High Court says, the KSAT says there's no recovery. The disciplinary authority says KSAT sets aside recovery.
The second round said.
Second round, interestingly, it doesn't challenge his finding of guilt. Only the state carries on recovery. He never challenges the finding of guilt by KSAT. So his guilt of negligence has attained finality. So he is here aggrieved saying that he doesn't have to pay the 8.5 lakhs. The High Court set aside KSAT saying there's no reasoning and no reason to set it aside.
My lords, a week's time for rejoinder.
We understand that you are appearing for. You are working in whose chamber?
My lords, the state of Tamil Nadu says private matter. It's private matter.
So we appreciate your anxiety and concern. We will not dismiss it today. Let the council be.
I'm obliged.
List on. Put it on inky request. हाँ? Rejoinder का जरूरत ही नहीं है ना. Have you understood what we have done?
My lord, listed on.
Why?
Main council should be there.
Because you are a young council at the bar, we don't want it to be on your.
My lord has been very kind to all of us. Very
My lords.
Next.
Same prayer, 2 weeks. My lord, 2 weeks time I'm praying as a last.
No, you're not a.
No, my lord. But only issue, my lord. Only.
No.
My lord, I bow down to what has fallen from lordship. The LPA was, my LPA of state LPA was dismissed for delay of 229 days, my lord. That was the issue, my lord. Main issue was 229 days delay. So
Even on the main merits, complaint about the delay.
No, my lord. Apart on merits, I've got a very good case, my lord. There is nothing like that, my lord. Why I am saying, my lord, the respondents herein have never faced any written examination, interview, or something like that, my lord. They are claiming parity with the other persons who have qualified the examination and have been appointed under.
Village extension officer is the post.
Yes, my lord. Village extension worker, not officer.
That's
No, my lord. Kindly bear me. Kindly, my lord. It requires consideration. Kindly consider, my lord. Kindly see what
peculiar facts.
No, my lord.
Not
Kindly
to be
see.
treating as a
My lord, kindly see for a couple of minutes, my lord.
not
Only.
to be treated as a binding precedent. चलिए आगे चलिए. Next please.
Your Lordship, the present matter is still.
Mediation is in progress. Put it.
Please the court.
I appear, I'm appearing on behalf of State of Karnataka and the proxy council.
The adjournment is that Lokayukta matter. Why
Yes,
will
ma'am.
you take adjournment?
No, Lord, on the last date, I moved the adjournment. Chief Lord, on the last.
Why?
Last occasion, Lord, Mr. Povey had appeared and he expressed his inability to appear, Lord, this week. And we mentioned, in fact, Lord, the matter, and your Lordship says that.
List on को date दीजिएगा. Important matter है इसको date दीजिए.
Lord, could it be in the second week of September, Lord?
No.
Your Lordship, Your Lordship, I only request. It's 19th of this month and 16th of September. You may kindly accommodate me on those 2 dates only, Your Lordship.
19th of?
19th August and 16th September.
19th August.
No, Your Lordship, I do not want on that
You
day,
don't
except
want.
on that day. Sorry.
In fact, Lord, Mr. Povey is traveling, Lord, from the 25th of August to the 6th of September.
Then you argue. Sorry.
Lord, may I just request, Lord, any date prior, Lord. Any date prior, I have no difficulty. Lord.
What date are you?
Tomorrow. Lord, tomorrow, not here this week, Lord. Next Tuesday, Lord. Next Tuesday, next Wednesday.
Tuesday is not available. Wednesday. Okay.
I'm so grateful.
20th.
Posted.
Yes, please. Yes, please.
I'm ready to argue the matter.
Time to file rejoinder. You have not filed rejoinder, but doesn't matter. Argue. Last time it was adjourned only for that reason.
I'm rejoinder, but we are ready to argue the matter.
Do you want to file or not is what we are.
Very well. We will file it.
Then don't.
May I request, Mullah, then let it be a last opportunity, Mullah. That next day it is heard, Mullah.
No, he is ready to argue, but he doesn't know what he will argue.
He wants to file rejoinder, but he is ready to argue.
Indulgently, by way of last opportunity. 1 week time is done to file rejoinder. At least on. Close the case.
As well.
My lords, I appear for the state. Yesterday only I filed the counter affidavit in the matter.
Ma'am, only thing is that there is a dying declaration and there is child witness. What do we
This is
do?
a fit case for conversion for section 304 IPC, my lord. It was a case of sudden fight. Secondly, my lord, I've already undergone almost 12 years in prison. And my behavior in jail is good, my lord. Page 85.
See, we can't do that. After 2 more years, you'll be entitled for remission.
Look, page 85, custody certificate, my lord. My behavior is good, my lord.
No.
Jail.
Good people inside jail also.
On merits, my lord, it was a case of sudden fight, my lord. These were four
Not a
IPC.
case of sudden. You don't strangulate your daughter-in-law in a sudden fight, huh? The dying declaration.
Lord, it's just that the brother-in-law and
On injury,
the deceased, they had some fight and got very angry and was burned.
Service is complete. Service is complete.
Sorry?
Service is complete in the matter.
Please argue.
Your Lordship, we have instructions to file counter from the department, Your Lordship. Give us last opportunity to file the counter of Your Lordship.
The only thing is that 1 year is more, is in excess. That's the only thing. What do you say?
Your Lordship may give them time. We have instructions to engage a senior counsel in the matter.
Engage a senior counsel. Maybe we are sympathetic. Why don't you argue yourself?
Already reduced to 1 year, 3 years. to
Ah,
1 year.
exactly. That's. Huh?
Lordship, please grant us 3 weeks time to file counter lordship.
You should only have sentence. Huh? That is.
Refund. My lords, I seek to short passo 31.
Aso?
Yes.
Aso will not come today. Anyhow, they'll stand as it is. Paso.
Lords are granting passover.
Right.
Who is to argue this?
Being led by Senior Counsel Mr. Shekhar Devasa.
Okay.
Please, my lords.
My lords.
Yes, please.
My lords, I require 4 weeks' time to file the rejoinder affidavit in the matter, my lords. My lords, the petitioner lives in the remote village, so I'm unable to get in touch. So I request for the same, my lords.
Rejoinder 4 weeks.
Obliged, my lords.
Please,
Lordships, in 1933, just as a matter of housekeeping, item 33.6 and 33.7 don't relate to the same recruitment year and advertisement, and the issue is completely different. We are under old rules. And the rest of the batch of 33, even last time, your lordships, we had mentioned that, and lordships have agreed to segregate it. However, it didn't come in the order, your lordships. So we
No, which is
33 up to 33.5 are regarding women's reservation in the 2014 recruitment.
15.
15. Ours is 2011 recruitment, and it relates to the publication of the second merit list. And it has nothing to do with women's reservation, your lordships. So 2 separate matters altogether, but same recruiting agency. That's the
which are the ones which are to be segregated?
33.6 and 33.7.
Yeah. So what about the others?
Others, your lordship?
Other, I beg to appear in 33.2, which is though the main issue.
We just want to know, reservation apart, issue apart, what is the right? What is the right of the candidate?
Well, the right of the candidate will be the carrying forward cannot be arbitrary. You have the discretion, but you can't exercise it arbitrarily. If I'm able to demonstrate to the court that yes, I had a right at that point of time and I was denied arbitrarily, then perhaps your lordship will be interfering. That's all. And I'll demonstrate it from the record that how arbitrary that exercise of power was.
Let's see.
Yes, ma'am.
Let's see what.
Yes, ma'am.
Your lordship, my only motion, the counsel for the state does not seem, I'm appearing for the commission.
I'm here, your lordship. I'm here, your lordship.
For this state.
Mr. Dwivedi
I'm
is
here,
there.
your lordship. The counsel for
He's
the
all
state,
right.
your lordship,
Okay,
I'm
I'm
here.
sorry, I thought there's nobody in the commission.
Is there?
Please.
But whether it should be carried forward or not, the remaining, the advertised vacancy is X and they don't fill X. And then they come up with reasons which are not right. That's perhaps the common canvas in all these petitions. What Ms. Makhija is saying is perhaps for quite a different recruitment year. But that's all. A quite different RR. Maybe I have a different thing. I have something to say. There are inter alia issues.
All that we are saying is, let's begin, or you want a date? Let's be very
No, I don't want a date. It's not the question of me having a date. I'm just answering my lord's question as to what is the point. This is the point my lord is hearing it today. I'll argue it today.
Your lordships, I would like to argue mine because the issue is very short, because the rules provide that the second list has to come out. 2011 vacancies, your lordships, there are still 158 vacancies vacant, your lordships. It's a very, very short point. Because of this other batch, your lordships, my matter gets delayed as well.
Okay, then we'll segregate. No,
Yes, your lordships. Lordships will segregate and finish mine.
My matter
today.
and Mr. Makhija's matter same thing.
So item 33.6
and
7.
Yes, your lordships.
They have to be segregated.
Yes. Very, very short point. Even the High Court said come out with the second list, they haven't complied.
Retag कर दीजिएगा. 33.6 and 33.7. इसको कोई किसी
Tuesday,
Tuesday
yes, Your Lordships, any
और yes ma'am.
at the earliest possible.
जो भी convenient जिस दिन कोई मैटर ना लगाओ और जो बाकी के हैं 33 से लेके 33.5 तक 0.6 हाँ 0.3 तक 0.5 तक इनको किसी उसके बाद ट्यूसडे को लगा
I'm very, very grateful, Your Lordship.
D-tag.
We have filed one written submission which is common in all your lordship. So that
No,
can
no,
be used.
you file.
We have already filed your lordship.
Written note of submission. 1 minute. Let fresh written submissions be filed in each one of the cases.
Very good.
Obliged.
Great.
It will be done
Within 1 week,
1 week.
Very
we'll do that. Grateful, Your Lordship.
So, my lord, what I understand from my lord is Ms. Makhija's matters have been fixed on X Tuesday, and my matters, which are different, are posted thereafter.
Yeah.
So great.
The Makhija's matter, my matter also.
Your matter also. So grateful.
May I please, Willis?
Yes.
I am for the petition, Willis.
Yes.
This is pertaining to a notification of Unified Bihar by State Public Service Commission for the lower division clerk and lower revenue department pillars. Way back in the year of 1998.
Now kindly come to para 14 of the impugned order.
Yes, please.
What is your right? You tell us this. This is what the court has held, the division bench has held.
Yes, prior to that, may I come to the factual matrix of the entire matter, Willis? Because it is all pertaining to the same notification. Yes, please.
2004 note.
2004 Millers, the results have been published. And then after out of 59 selected and recommended candidates, 46 have joined. And I among those very leftover 13 candidates have been given.
Why they were left? Because the formalities were not completed.
Formalities were not completed, Millers. And the single bench has already given a verdict in my favor, Millers. And the notional appointment from that very date has been taken care of. That is the only thing which I am seeking.
What is the reason why these 12 candidates which were left out?
These are the administrative delay that will be better explained by the state ministers. They have not been in a position to attribute any such reason on the part of these very candidates, those who have been selected out of the same notification ministers. And they have been ranked higher as far as qualification part is concerned.
But would you be claiming seniority also?
No, Millers, I am asking the same notional position and appointment from that very date.
But minus the seniority and the monetary benefits.
Minus the seniority and monetary benefits, please.
Yes, so what do you say?
My lord.
See, point is very simple. Advertisement is the 28th of January 2004.
1998, Millers.
Sorry, 1998.
Bihar Public Service Commission, my lord.
1998.
Yes, my lord.
Correct.
Yes, my lord.
46 out of 59 were
taken in, they joined the job, my lord. They were permitted to join. The 13 leftover, my lord, was on account of verification, and the papers they have submitted before the Public Service Commission could not be verified on account of their fault.
1 minute, just.
Please, my lord.
We are only trying to understand the facts.
Please, my lord. I have prepared a short note, my lord.
The recruitment process started when?
My lord, my apologies.
Selection and appointments.
Selections advertised
in the year 1998.
2003, my lord.
Please, your lord.
21st of 98 started with the advertisement, my lord, but yes.
Correct.
Yes, my lord.
Eventually, the names were recommended when?
Names 2003. 2003, my lord.
2003.
Yes, my lord.
Out of whom, how many were recommended?
59 candidates, my lord. Out of, yes, my lord.
46 joined.
Yes, my lord.
46 joined.
Yes, my lord.
On 28th of January 2004.
Yes, please.
21st of January 2003.
3 or 4?
Recommendation for joining was on 21st of March 2023, Millers, and they have joined on 28th of January 2024. 2004.
That's what
46 appointed. Yes, Millers.
They joined on 2004. Correct.
Yes, my lord.
These 12 candidates were also part and parcel of that very same recommendation.
Yes, my lord.
Now, you'll have to tell us on record, because the learned single judge is in their favor.
Yes, my lord.
The High Court says that they have no right to say
Very fair, my lord.
that please appoint us also.
Yes, my lord.
Perhaps that part may not be correct, more so for the reason that when they are not at fault, You have to, from your affidavit, show us how they're at fault.
My lord, they were not part of the same recommendation. They were recommended by, in the year 2004, my lord. Earlier, the other 46 persons were joined out of 59, were part of the another recommendation, my lord.
No.
Whereas the,
Why were they not recommended is what we are asking you.
yes,
When the selection, advertisement is one,
yes, my lord.
examination is one,
Yes.
selection process is one.
May I clarify? I'm for private respondent. May I clarify some facts?
You are a private respondent.
I am for private respondent.
Your
I am part of that 46 people who are recommended in March.
your interest has been protected by him. He says he doesn't want seniority over you.
Only with respect to what is falling from your lordship.
Okay, no problem. You tell us.
Yes, yes. Lord, what has happened that initial recommendation took place in March 2003. Thereafter, my lord, appointment happened in 28th of January 2004.
Correct.
Thereafter, my lord, their recommendation, so far, so their recommendation was concerned, that was withheld by state because of, my lord, more than one reason, my lord. What has happened that these were people who belongs to one district in Jharkhand, and their roll number was consecutive, they all were close relative. In fact, there is a glaring fact, my lord, where mother and daughter both had taken that exam, my lord, and the age difference was of 5 years. So in that view, the state of Jharkhand, my lord, initiated an inquiry into all these aspects, that as to what has happened, what has caused their role.
Then
it has happened, my lord, in 2000, after my recommendation itself.
Then
in 2003, my lord.
But then ultimately in inquiry, they were absolved.
Thereafter, my lord, inquiry happened and they were recommended in July 2004.
Therefore, the apprehension or the allegation were found to be incorrect.
So far, so state is concerned, yes, my lord. They were absolved, my lord. But what has, there has been an intervening fact also, my lord. One notification came in July 2004, where, my lord, LDC and UDC post were segregated. So UDC became a promotional post. UDC was a direct post. Now it became, earlier to this, my lord, it was a direct post. After this notification of July 2004, LDC was segregated from UDC and they did not challenge this notification. This is one, my lord. Second, my lord, when their recommendation happened in 2004, till 2008, when they are finally appointed, they were sleeping, my lord. They never approached court, my lord.
Wow, they have been recommended in what capacity now?
Lower division clerk, my lord. Lower
division, LDC.
LDC.
Yes, my lord.
You are in UDC.
I am, because my appointment, yes, I am in UDC. I am in UDC.
May I submit, Willis? May I submit to this, Willis?
You'll have to explain.
Yes, my lord. I've already explained. Kindly see page 4, para 8 of my counter affidavit, my lord. The following facts are contended by the respondent 1 for better appreciation. Bihar Public Service Commission, by its letter dated 1092, dated 31st of March 2003, had recommended for appointment of only 49.
Their mistake.
My lord, I'm not saying their mistake, my lord. They do not have any right to claim that they should be appointed once they participate in a.
Why did you then?
I'm coming to that, my lord. I'm coming to that. Subsequently, I'll come, my lord. What I'm saying that, my lord, their fault is that their conduct was itself under question, my lord. Their papers, the application forms were
incomplete. You did not cancel their candidature.
No, my lord, I did not cancel. I did not
cancel. Your conduct will not come into the picture.
My lord, before making an appointment, my lord, I have to verify each and every.
So if there is a negligence or delay on your part,
not my part. That what they say.
Where is that we are asking you? Please, in your affidavit, you say that they were any delay or lapses is attributable to them. Is what we are asking you. We are only asking you this.
Yes, my lord.
You will have to say in your affidavit.
My lord,
The
kindly,
High Court doesn't deal with this aspect.
my lord, yes, my lord, High Court has not gone to the, kindly give me 1 week time, I will file better affidavit on this. Oh, my lord.
We'll record your statement. You don't claim seniority or arrears.
Yes, Millers, but only one submission. In pursuance to my learned friend's submission, these very completely incorrect facts what they are trying to mislead as far as the private respondents are concerned. They are saying about 10th of July 2004 demerger notification.
Forget about what the private
Yes,
is
Millers.
saying.
Yes, Millers.
Are you ready to make that statement?
Millers, I am ready to make that very statement to that very extent that joining with notional appointment as far as the single bench order is concerned, that should be complied. That is all. I am not seeking any arrears to that very effect, Millers.
Sorry.
That very effect can be, that very statement can be taken on
Seniority will be an issue.
at par with that of the people, those who have joined in 2004, Millers. My very claim of appointment.
Seniority cannot be an issue. Anyhow, you take instructions. Why make a statement today?
Yes, Millers.
Take instructions.
My lord, in fact, before LPA bench, they have already waived off seniority. This is.
He has to make a correction or no? The state filed an affidavit explaining the delay stroke latches, if any, attributable to the present petitioners in issuing the letters of appointment with regard to the very same selection process in relation to which the private respondents stood appointed on 28th of January 2004. When were you appointed ultimately?
2008, Millers.
We noticed that the instant petitioners were appointed
28th of January
only on
2004.
29th of April 2008 or
January 2004. 28th of January 2004.
You were appointed when?
2008. 29th of April 2008.
29th of April 2008. Whereas the private respondents were appointed on 28th of January 2004.
You also giving any returnable date?
We are giving it date. Affidavit within 3 weeks. Rejoinder 1 week. List on.
Grateful, Your Lordship.
Your Lordships were being led by Senior Advocate Miss Anita Shenoy. She is on her legs in court 1 and will be seeking a passover.
Wait, please, Lords. Lords, this was a partition suit. Lordships had issued notice in January of 2024. Thereafter, we filed the process fee. The process could not be issued, and therefore I had filed an application seeking Lordship's permission so that.
What is the error? You tell us that.
The error, there are 2-3 major errors in the impugn order. That's perhaps made with the court when the court felt like issuing the notice on 24th of 2nd of January.
You have been given 1/3 share.
Yes, my lord. According to me, the respondent number 1 and 2 are not entitled because the succession opened in the year 1939. That's when
they are your sisters or no?
They are not my sisters. They are sisters. They would be sisters through the grandfather, great grandfather.
Whatever it is, they are part of it.
And one of them is not even a sister because she was not the daughter of the alleged daughter of my great grandfather. So therefore, she could not have claimed. I have raised that defense in my written statement. And there are 2 aspects to it.
Kanhaiya Kumar had one son, Gajendra Pandit, and he was married to Sumoni.
Sumoni.
Now through them,
yes, Lord.
Through the said wed law,
yes, Lord.
They had 6 children.
Yes, Lord.
3 sons and 2 daughters.
Yes.
And the plaintiffs are the legal heirs of.
Now that's the point, my lord. My lord has page E perhaps in hand. That's where the family tree has been given. Page E, my lords, has that. There are 3 crucial facts which my lords have just pointed out. Mr. Kanai, who is the common ancestor, passed away in the year 1939.
Correct.
That is before the Indian Hindu Succession Act had come. And allegedly after 1937, the Right to Women's Property Act had come. In this Paragana, that 37 Act was not even notified. That's why that's what weight with
whether you are entitled to 1/5 share or the plaintiffs are entitled to 1/5 share or 1/3 share. That's the only issue. The question is only of share, not entitlement.
That's what I
If
wanted.
that is it, so then why not 1/3?
Because
According to you,
yes, Lord.
according to you, they should get nothing. If we were to
No, my
give
lords,
you,
that's why, permit me to, there is a reason why I was drawing my lord's attention about the share only.
gentlemen,
Yes, my lord.
with regard to the entitlement, concurrently all courts have held they are entitled to.
Even if we take on the entitlement, the extent of entitlement, there will be an argument. And that's why I wanted my lord's attention at page E.
Sorry, sir.
Let's just kindly have page E for a moment, my lord. I will convince the court.
Thank you.
Right, 1939, when the act was not even in place.
Women have to be pleased.
I am not saying they are not entitled to, they will be entitled to 1/6 or 1/12 and not the share which is granted by the court. Let's kindly have the page 18, which I have raised this fair and square the grounds.
Thank you.
Permission of your lordships, may I be allowed to withdraw the petition as the order of the Honorable High Court has been complied with by the state of Odisha.
Very good. Seeks permission to withdraw the present petition for the reason that the order is already since complied.
Grateful.
Lordship, in item 38, the main counsel is still in court for.
Your Lordship, rejoinder was to be filed. Rejoinder has been filed on behalf of petitioner.
It's only a question of disability.
Your Lordship, the main counsel is still in court for, Your Lordship. Kindly pass over.
Your Lordship, I have to. Your Lordship, I have another matter in Gurgaon. It is only for the filing of rejoinder. I have filed the rejoinder.
We appreciate the innocence, but we must correct you. Arguing counsel not well. Okay. Not well for 4 weeks. 4 weeks.
Hello, I appear for the respondent number 1 in this item 39, Milos.
No problem.
Item 40 requesting for passover, Your Lordship. My senior colleague is in court number adjacent.
ये passover तो बड़े हो रहे हैं. We are very indulgent, it seems.
She is all her legs, Your Lordship, in court number.
Tomorrow onwards, we are making it clear now. We will not no passover. If this is how the final hearing matters, you're going to take passover, then every matter is passover. Anyhow,
When you know that at 2 p.m. some other matter will be taken up.
No, Lordship.
Passover is in fact a prayer for adjournment.
Well, in fact, she is on her legs, Your Lordship, in item code 13.
ठीक है, passover कर देते हैं.
So grateful.
With respect to respondent number 1, the service is completed, my lords. With respect to respondent number 2, we've just received the affidavit today. We'll take it in due course. That's may grant me a week or two's time.
No, respondent number service report says not served.
With respondent number 1, it's served, my lords. The office report says.
No. Notice he left without instructions, unserved.
Because thus the service had been served, my lords. My lords may look at the office report.
Okay. As per office report, office report dated 11th of August 2025, respondent number 1 stands served through dusty service. Respondent number 2 not complete. His service core number 2 is not complete.
2 weeks time may be granted.
The reason being that the petitioner has not taken steps. So let the needful be done, now done, as preferred, now done within a period of 2 weeks, failing which the petition shall automatically stand dismissed from non-prosecution without any further efforts. In the event of steps being taken, notices issued, returnable tax.
My Lordship, I am seeking crossover in this matter. We have been led by a senior advocate, Mr. Rahul Kofi. He's another.
ठीक है, पास हो लीजिएगा. कोई बात
Your Lordship, I am seeking a short adjournment. I am appearing for private respondents.
Adjournment today.
My Lord, in item number 43, I am entering appearance on behalf of respondent number 1. He has, though the office report is saying that he has been served on 20th of June, but actually he has been served on 28th of July.
How does it matter?
My Lord, I am seeking 4 weeks time because he is not well. So he has not visited. I will file my wakalatnama on behalf of respondent number 1.
Steps No, you are for number 1. Huh?
Yes.
Now, what about 2 and 3?
So, sir, they are, my lord, they are pro forma respondent basically. So he is the only contesting party.
Respondent number 1 is the contesting party, whereas respondent number 2, 3, and 4 are pro forma respondents. Then respondent number 1 is permitted to file counter within how much time?
4 weeks, my lord.
2 weeks, 1 week.
Interim order may continue.
Interim to continue.
It's in item 44 requesting for a passover.
Pass.
Oh, but I am appealing with the respondent, but instead of passover, my lord, some other day, my lord.
It will come some other day only.
Oh, sorry. Which obliged.
46.
The fresh matter, Mama. Let's. The transfer issue.
Transfer now, you tell us.
So I'm only limit.
We want to help you. How best we can help you? Tell us that.
But I'm only limiting myself. I'm only limiting myself to the impugned order paragraph number 12, my lord, the last paragraph.
What can be done?
I'm sorry, man?
What can be done for you?
Lordship may come to the paragraph 12 bottom, my lords, last 3 sentences. No, the High Court has overreached beyond the prayers of the OA as well as the writ petition. That's all I'll say.
Page 11. Page 11. You are the petitioner with the High Court.
I was a petitioner before the High Court. The respondent number 3 filed an OA.
1 minute. Last thing, 9. He's only agreed with that.
That's one. This should have been done, my lord. And she's a lady. And I work in the accounts department in Bangalore, my lord. All the head offices of the major institutions are in Bangalore.
You only agreed of this part of it. Consider. You only agreed of this. Notice you're of this part of it.
Only that what my lord may state. That's it. I am not pressing anything beyond. Let the government take any decision. If anything, that will be subject to outcome of further OAs will be filed.
Of the directions issued.
Paragraph 12.
In paragraph 12, following direction issued in paragraph 12 of the impugned order. Here, page 11, dash to dash 2. Notice confined only to this aspect. Returnable quoted. We'll say notice only to the state.
That's also sufficient. That will suffice.
At this stage, notice confined only to respondent number 1 and 2. Who's the standing counsel?
Mr. Raghuvar, I'll send it on. There are a couple of.
Trying to, in addition, see, the aforesaid action shall, in the meanwhile, shall remain stay.
That's the addition.
That's this.
Deeply.
Please, Lordship. Lordship, in this case, none has put appearance on behalf of respondent number 2, who is private respondent.
State your Lordship.
And
The possibility of settlement, no.
Lordship, respondent 2 has not put appearance, so how can it be said?
So when what do we?
Lordship, I have a limited prayer.
Yeah.
Actually, by impugned order, High Court has imposed a cost of 50,000 on both petitions. This is arising out of 2 quasi petitions, one against DB case and one against 125 case. So as the case was not decided on merit, counsel for petitioner has not appeared on that day, and matter was dismissed without hearing the counsel. So
वो वकील साहब नहीं थे ना, अभी तो उसके सच Respondent number 2 stands served.
Yes, Lordship.
As per
Office report says so.
As per office report, respondent number 2 stands served. None has chosen to enter appearance. Consider view that the impugned order needs to be quashed in such side. For the simple reason that the petitioner, instant petitioner, was not informed. Adjournment was sought on behalf of the petitioner on the ground that the arguing counsel was not available. So the petition also, another petition was filed by the instant petitioner seeking quashing of proceedings instituted by the respondent under section 125 CRPC. Well, these cannot be the grounds for rejecting the petition filed by the petitioner under section 482 of the CRPC. So, in our considered view, the court also erred in imposing cost of rupees 50,000 on the petitioner. Such proceedings allowed order such that we direct the parties to appear before the High Court. The original petition is restored to its original number. Direct the parties to before the High Court on that. And on which to be
Any fixed day for appearance?
we are giving party we request the court to decide the petition.
This is the case, Milord.
We have seen your affidavit, you have filed an affidavit.
Yes. Lordship, in this matter, I am being led by Mr. Naidu for the appellant. Milord, one thing I wish to make clear, whether today or later. Milord, I don't want to say anything against any lawyer. Things have happened. It happens, Milord, a lawyer gets an affidavit, he believes an affidavit that's of a client and he files. I have nothing against the lawyer. Our simple plea is, Milord, whether in the vacations, the manner in which, Milord, our appeal was sought to be made infructuous by saying that we withdraw our writ, which had since been disposed of. We are agreed by that. We want the appeals to be restored. Yeah. But we have nothing against the lawyer. I'm not interested in all that. So whether not today or today, I will take it.
He was here in the first round, Lordship, and I know
No problem.
That's all right. I'm not saying no.
Lordship, may just accommodate me for today.
Yeah.
Of course, we'll accommodate.
Would Lordship keep it on 26th, Milord? That's a Tuesday.
Not 20, not 1 week later. Not 1 week later, if you not.
No problem.
And Milord, I have filed an application for intervention, Milord, for the purpose of because there is an allegation made against the son.
No problem.
Of respondent number one.
Your application allowed, no problem.
Lordship, that application is 17162.
26 के बाद कोई जो
So, Milord, maybe then have it on 9th. 9th.
Your son of? Sorry, Milord, the respondent number 1, V. Kameshwar Rao.
His son. Because we are making an allegation against that son now.
Against
Because
that son.
according to us, Milord, he is the man who did all this.
You want an inquiry?
So, no, Milord, I don't.
Why are you joining?
Milord, I want because there is an allegation made against me and therefore I have.
I welcome him. I am going to argue that.
Why I'm
I
saying?
welcome.
Why should you?
Welcome, welcome.
Lordship may take up this application on the next day.
You don't
No,
want
let it be allowed. You are welcome. Milord, don't do that.
Milord, I am appealing for two lawyers, Milord, who has given no.
No, just 1 minute. You are not here.
No.
Mr. Rothgi has already said that he doesn't want to agitate anything
against any law.
against any of the law.
Then the two lawyers be discharged. That's my request. Now as he doesn't want to go ahead, so there.
So Rothgi will not object if we proceed to. take action against.
There can't be any discharge till your lordship's here. Till your discharge.
We may proceed.
Court can proceed because
A wrong statement is
many
made.
things have happened in the
Power is
past.
procured, so we may proceed against the
Your
law.
lordship's
can-
right.
it is my
Lordship's
request
right
that-
in the vacation court is taken away for the
Yes, yes.
lordship's may decide.
There is no doubt, Lord, that there is somebody behind who has done all this. The lawyers may be. What happened?
Because the lawyers will not.
Today we are not saying
Anything. But all right. Next date.
Let the matter come on second, Milord, which is.
No, second, I have difficulty.
Ninth.
Ninth.
No, there's one preempt, if they want to.
But this is very rare when we are allowing the petition and he says, don't allow my.
Got it now, he realized it. My lords have given a clue to him. He given a clue.
No, I'm not making, Milord, on the record that I have. Quickly fell from the bench.
All the 3 wickets down now.
On a record, the record that I have before me, Milord, as a lawyer.
Ninth.
There are 2 other applications to which if they want, they
They
can
have not
file a
filed.
counter.
But they have not filed as of now. In spite of the lordships, whoever wants to file.
Once again, recall application, the others
File
are
schedule.
not let them.
Let counter be responsible
Other
for the application.
Very well.
Within
Lordship, please.
within 2 weeks.
Very well. Obliged. Right.
Please. Yes.
This is the motor vehicle accident.
Correct.
Both the courts, they rejected the claim of the
Why?
2 deaths, only on the
Hearsay.
tribunal as well as the honorable high court.
Hearsay.
Hearsay because at 11:30 night is the accident was happened. 11:30
When did
night.
when delay also, no?
No delay. Delay next day they themselves is filed a complaint. 14th August 2013 is the melody.
Any possibility of settlement?
No, my lords, both the courts have unanimously hold, my lords, that
We know that it is hearsay.
not even a single evidence.
PW1, PW2, both are there. Hey, 1 minute.
Sorry, my lords, I'm sorry.
You have an excellent case.
I'm sorry, my lords, I'm sorry.
We are only saying after all, accident has taken place or no. He was 26 years of age.
Yes, my lords.
Some compensation.
One is 22, one is 26.
No, two people died.
22 one, another one 26 minutes. But the owner and the driver are not disputing the accident. They're not disputing. There is a FIR, charge sheet is filed.
1 minute. We are on your behalf. We are persuading him.
Because they ought to have filed then under 163A. They would have got rupees 5 lakhs each. They did not have to prove rash and negligent act. Now, my lords, today, not even a single evidence, my lords, is there, my lords. Both the courts have, my lords, have meticulously, my lords, appreciated the evidence that how the false witnesses have been created, my lords. PW3, PW4, my lords, comes up and say that we heard the owner and driver talking to each other on a bus stand. That he had hit the.
We have seen it there. We are only saying some reasonable amount you pay. That's it.
Because then I don't have instructions for that, lords. I'll have to seek the instructions.
Take instructions.
Yes, we'll do that.
Death has taken place. Accident has taken place.
There was an FIR against this.
FIR, exactly.
Not against this vehicle, my lords. Some unknown vehicle, not even the type of the vehicle has been identified in the FIR.
Charge sheet is filed, my lord, against the driver as well as the owner. Charge sheet
Had
is
there
filed.
been an FIR and lorry mentioned, type of vehicle, my lords, I would have mentioned.
Is there or no?
So charge sheet is there, but this judgment.
Vehicle is identified by the
Correct.
IO. How can the driver be made an accused?
Lords, with respectfully, lords, I would.
Or is made an accused quite a vehicle.
Yes, my lords, he has made the vehicle, my lords. But my lords, then if your lordship permit me, my lords,
Don't worry. We'll of our own do it. Don't worry. We'll of हम ही कर देंगे. हाँ. हम ही कर देंगे. We'll allow it. What is the amount? You tell us.
I'll just.
Lords, but
What is the reasonable amount?
My lord, one is, my lord, is working as a loan recovery agent, my lord. The another is a bar binding contractor. My lord.
No, what is the income which you?
What the income? They said it. One, the loan recovery agent, the Mr. Sunil Singh, the 26 years old, he is receiving 40,000 per month. The another melody, the bar bending, he was earning 50,000, it was mentioned in the claim. The salary certificate also, melody, the appointment order is
there now.
based on
Yeah,
record.
CAV comes.
Lords, with due respect, Lords, I would like to submit, Lords. This honorable court, Lords, have held, Lords, in Safiq Ahmed, Lords, that false witnesses are created, Lords, and now that this honorable court has.
Deal with your submission, no problem.
Lords,
we have to, in any case, reverse. When we are reversing the findings, we have to deal with the findings. Now you give your written submissions.
We'll do it that, Lords.
Let written submissions be filed within 1 week.
We already filed it.
File it again.
I'll file it.
Lords, 2 weeks, Lords.
2 weeks, no problem. All matters passed over, they will.
Well, items. Permission to mention that matter. Mr. Sibal is on his legs in items.
Sorry, we are not.
Lords had indicated that if Mr. Sibal is in difficulty on.
No.
That matter is over.
No, it's going on. He is on his legs in court 2 as item 30.
No problem. We'll
Court 1, he said that he will be busy in court 1 in that advocate matter.
Yes.
No, Bihar election matter, election commission matter.
Anyhow,
He's requesting if your lordship may have it heard.
We'll come at 2 o'clock.
Your lordship's
item- Your
I
lordship
have
has
indicated that if he is in a difficulty, we can mention.
We have no other case.
We have no other case. We have adjourned in bad matters only because of this.
It's a humble request. He would have
We'll
been.
reassemble at 2 o'clock. We'll reassemble.
Your lordships, the other matters are getting dates,
There'll be some dates to be.
some dates. Very good.
May please. I understand Mr. Sibal was in some difficulty. I think it made over.
But we said we'll assemble at 2 and then whatever is to be done, we'll tell us.
Yes, I leave it to your lordship. Otherwise, my lords, I'll.
No. We are not saying that we will not adjourn for Mr. Sibal. Should Mr. Sibal,
Thursday?
when do you?
Thursday.
We'll accommodate Mr. Sibal. There's no difference. We are.
I leave it to your lordship. But otherwise, I'll carry it on.
No, you're always welcome, sir.
Yeah. But Mr. Sibal is on his legs. That's all.
You're always welcome. Then after Mr. Sibal finishes, concludes your wish to add, there's no difficulty.
Your
We will
lordship is
definitely accommodate Mr. Sibal. There's no doubt. There's no doubt in our mind.
My lord,
Thing is, 1 minute, ma'am. Just 1 minute. One difficulty which we are seeing with another senior counsel is this, that twice we have, 2-3 times we have accommodated him. And we understand he's very, very in demand in other courts. Today also we had to adjourn. The only thing is that next date he should be there. That's about all.
Lordship may have it on Thursday or next Wednesday.
Not Thursday.
it's a miscellaneous.
Wednesday.
Lord's Thursday is a miscellaneous day.
Next Wednesday.
My lords,
What is that you wish to say? Okay.
my lords, could we just have one small request,
Yes.
which is that they have 3 eminent counsel. It's at the stage of rejoinder. Of course, Mr. Sibal must be accommodated, and he's in if he's on his legs. But my lords, perhaps my lords may consider that given that there have been 11 adjournments.
May I just only say one thing?
Yes.
On the last day, Mr. Patwalia got up to say some date. And I responded to Mr. Patwalia by saying that we are not a vending machine. You insert a coin and judgment will come in. When I went back, let me share this with you. And Mr. Patwalia is here. I must apologize to him.
No, not at all.
No, 1 minute.
These things happen in court all the time.
1 minute. When I went home, let me tell you, all my law clubs and interns are sitting here. And they told me that perhaps, sir, you were unduly harsh to Mr. Patwalia.
They do not know, my lord, for how long.
1 minute. No, I am. You know me.
You should have told them, my lord, that when your lordship was in Shimla and Chandigarh, since then.
You know me. I admit my mistake. I apologize.
No, there is nothing. I have forgotten about it now. Don't.
Ma'am, only thing is, what is the tearing urgency?
I understand.
That's it.
Wednesday.
Simple.
Wednesday.
After all, they are asking for 1 week only. We know that there are 3 counsels. We also know that Mr. Devan is finished. We have been accommodating each one of you day in and day out. There's no difference.
Absolutely, my lords. There's no doubt about that.
Please.
Wednesday.
Wednesday का board day. Wednesday, no.
Wednesday means tomorrow. Next Wednesday. Obviously not.
अगले दिन, not 20th.
20th.
See, there is 1% chance of this 20th may not be convenient for me personally. 1% chance, but I'm not sure. If I'm, then we'll move on the premise that we'll keep it for 20th. But if I'm not there, then you'll have to accommodate me.
Goes without saying.
All right.
And then it'll go to next 8 months of time. नहीं फिर 26 को करेंगे 26 26
Yes,
26
26 Tuesday. That's good. 26.
Then your lordship may keep it only for 26th, then to begin with only, then why?
Or would 25th also suit? I think 25th.
25th is also all right, end of the board.
Monday.
End of the board we can do, yes.
Monday. Which 20th? 25th.
25th Monday.
So,
26th.
26th better. 26th.
What we'll do is then, Mr. Patwalia,
26th is okay.
26th, we'll keep it in the morning.
So grateful.
We'll keep it in the morning.
All right.
Please inform Mr. Sibal. 26th morning, we'll keep it top of the board.
All great.
List on 26th, top of the board.
My lords, may I? My lords, may I? My lords, some very new arguments have been made that are not before the courts below. So we will just take a very brief time to address my lords after they are done.
No problem.
So great.
We have told you that so great. Till the time everyone says thank you very much, we will not.
We are so grateful.
So 26th, immediately after the fresh matters, hail and other matters, TP matters, we'll take it up.
As your lordship.
Thank you.